Hello again, Attorney Peter Angelis. I'm here with another post regarding the Michigan no-fault law. Today I'd like to discuss when an individual can maintain a lawsuit against an at-fault party, in other words, the other driver who may be at fault for personal injuries. As you will recall from my earlier posts, generally when you're involved in a car accident here in Michigan, you have to seek benefits from your own insurance company. Your own insurance company pays benefits for your medical care, your replacement services, your attendant care, your attendant services, and also your wage loss. Those are called first party or personal injury protection benefits. But let's say you're very seriously injured, or heaven forbid, a claimant has suffered death or serious permanent disfigurement. When can you maintain a lawsuit against that at-fault driver? In Michigan, these types of claims are known as third-party bodily injury claims. And the statute says that if you are involved in a motor vehicle accident and you have suffered a serious impairment of bodily function, which has been objectively manifested and which has affected your ability to lead a normal life, you can sustain a cause of action against the other driver. The other criteria or the other basis for sustaining such a third-party bodily injury claim is if you have suffered death or serious permanent disfigurement. We all know what death is. That's pretty objective, pretty easy to understand. We also clearly understand what a permanent serious disfigurement is, or a scar. That's pretty easy to understand. The type of injury that really creates a lot of controversy, a lot of litigation, is where the injury is claimed to be a serious impairment of bodily function. The courts and the trier of fact will look at several criteria, and this is all governed by the statute. The statute that we're talking about is Michigan Compiled Law, Section 500.3135, and that statute defines what a serious impairment is. The serious impairment has to be objectively manifested. So in other words, you cannot just come in and complain of a headache or your arm hurts you or your back hurts you. There has to be something more than just subjective complaints. There has to be something that can be observed by your physician, independent of what you're saying. A good example of that would be a positive MRI, a positive CT scan, some type of positive testing. If the physician is able to see a spasm or observe something and make a diagnosis based upon the physician's observations without any input from yourself, that is objectively manifested. The next element is that it has to be an important body function. It can't be like your little pinky. It has to be an important body function, like a joint or your back, your neck. It has to be an important body function. And there's a whole body of case law what is considered to be an important body function. Finally, the injury has to affect your general ability to lead a normal life. The injury, like I indicated earlier, doesn't have to be permanent, but it has to be something that is more than just transient. It has to impair your ability to lead a normal life for something more than just a few days or a few hours. The courts and the trier of fact will look at your pre-accident lifestyle. If you were a jogger, weightlifter, you enjoyed biking, golfing, and then because of this injury, you're not able to perform those tasks. That would be sufficient to show that your injury has affected your general ability to lead a normal life. One other example, of course, would be if you're not able to work for a period of time. And again, when I say a period of time, it's not defined, but it has to be something more than a few days or a few hours, possibly longer than a few weeks. Certainly, if your injury has impaired your ability to lead a normal life for 30 days, 40 days, up to 6 months or longer, that would meet the criteria of affecting your general ability to lead a normal life. So that's what's called a third-party bodily injury claim. And again, that is all governed by state law. There's a statute that's right on point, and there's many decisions that have interpreted the statute and defined what constitutes a serious impairment of bodily function. Thank you for checking in. If you have any questions, please feel free to contact me. Again, Attorney Peter Angelis.